We here at the Indian Wills Clinic would like to give a little information on why family members should be avoided as witnesses to your will. We would like to go through why that is and what you can look for to have strong witness candidates so you can avoid any misinterpretations down the road. In most states, the witnesses to the execution of a will need to be disinterested parties. In other words, they should not stand to inherit anything under the will. If a beneficiary were to serve as a witness, the will's gift to that person could be declared void by a court. An example would be your spouse or sibling. Family members, either by marriage or genetic lineage, would be perceived to be interested parties and should not be witnesses to legal documents. The key is to find a person who is impartial or someone who is not a family member who is not receiving a gift from the will. A good witness should be 18 years of age and entirely independent of the person making the will. The witness must understand what it is they are witnessing. This means that they need to understand that they are witnessing your signature on a legal document. It does not mean that they need to know the contents of the will, and it doesn't even mean that they have to know it is a will. But you should not mislead them into thinking it is something else. If there is a reason to suppose that they would not have signed it if they had known what it was. If at a later date the signing of your will is called into question, the witnesses may be asked about it and will need to be capable of giving evidence in relation to it. For this reason, you may consider asking people other than close family members to be witnesses. And you'll need to be sure that those you do ask have sufficient mental capacity to understand what they are doing. You must sign your will in the presence of at least 2 witnesses, both of whom are present at the witness at the same time. Although we do not want witnesses to be related to you, witnesses do not have to be independent of each other. So for example, you could ask a husband and a wife to be witnesses for you. The key to remember from this video is to have witnesses that are not related to you, and they also should not benefit from the will if they are not family, but you would like them to have witnesses. As a general rule of thumb, beneficiaries should not be witnesses to a will execution. If you follow this game plan, you should avoid any controversy in the future with regards to how and who witnessed your will. I hope this answers some questions and provided some help to those that had questions about these types of situations. Thank you.